Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody. How are you? Happy holidays from Mulcahy Law Firm. My name is Beth Mulcahy, and I am welcome to First Fridays first. Welcome to our First Fridays for December 2025. And also wanted to just do a shout out for the Neighborhood Services HOA Academy, which we're doing this First Fridays in conjunction with our December Neighborhood Services First Fridays as well. So thanks everybody for being here this morning. I'm going to give you a few minutes to join. I think everybody's kind of in holiday mode already because we only have about, just under 30 questions today. So not too many questions. Probably everybody's already thinking about holidays. So just some introductory remarks. My name is Beth Mulcahy, and I'm the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. We're so happy to have you joining us today for our firm's live virtual First Friday event in conjunction with our December Neighborhood Services HOA Academy, Virtual HOA Academy. So thanks so much for being here in the month of December 2025. Just some background information on me before we get started with our presentation today is our firm currently represents over 1,000 planned communities and condominium associations in the state of Arizona. And for those of you who haven't met me, my name is Beth Mulcahy, and I'm the managing partner and founder of the Mulcahy Law Firm. In addition to representing over 1,000 associations in Arizona, I also currently serve on my board, actually two HOA boards, a master and a sub. And I've been doing that now for not all at once, but collectively about 16 years. First, I just want to start out today by extending a big thank you to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for your continued partnership regarding the Virtual HOA Academy series with our firm. Thank you for caring about your residents and for your continued support of these virtual classes. We already have actually on our webpage for our firm at Mulcahy Law Firm, we already have our classes listed for the first half of 2026. So we would encourage you to take a look at that. As always, we're going to continue with our First Fridays, the first Friday of every month, but we also will be continuing with our Neighborhood Services Virtual HOA Academy throughout 2026. And that's always the second Tuesday of every month, the third Tuesday of every month. And we don't have one in December typically because of the holidays. Okay, let's talk a little bit about how First Fridays is going to work. Because we're teaching this class today in conjunction with our Neighborhood Services Virtual HOA Academy, I thought it'd be a good idea just to do a quick little refresh on how we handle First Fridays. So if you haven't done so already, please submit your First Friday question in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will go ahead and answer any questions that you may have between now and 10 a.m. We may go a little longer if we get more questions. Just a quick friendly reminder, due to the large volume of questions that we typically receive, this free opportunity is limited to one question per association. So if you plan on submitting a question live during the presentation today, please include the name of your HOA or condo and your current role when you submit your question. Thank you for understanding. Okay, we're going to go right into just a quick reminder on something. We always kind of have questions that come up on holiday decorating. And actually, somebody showed me a picture yesterday of something that was kind of hilarious, a house that was over the top decorated. So we want to give you a friendly reminder about holiday decorations and associations. We don't want you to end up on the evening news, Channel 3, for being unreasonable as an association during the holiday season. So sometimes it's a good idea to have a holiday policy. If you have somebody that maybe has decorations that are making noise and maybe you're getting complaints from other neighbors, it's always a good idea to think about having a policy in place for your association for all holidays in terms of how long the decorations can be up before the holiday and after the holiday. And then also great idea to if you have a problem, just pick up the phone and call the homeowner and try to work it out. That's the best way to handle it versus sending a bunch of letters and fining. Most people are pretty reasonable when it comes to things like this. And we've had many situations that were resolved amicably by just picking up the phone and being nice and calling the homeowner and seeing if we can make some concessions, especially on the noise. They have Christmas carols or something playing, or a Christmas movie. We had one year where somebody set up a Christmas movie on their front lawn and they had it playing all day, every day during the holiday season. So just some suggestions to help your association if you're navigating that problem. Of course, you can always reach out to our firm and we can give you some advice if you're in that situation. Okay, let's hop right into the questions. Just in terms of the total number of questions that we have today, it looks like we are right at about 29. Our first question is from an owner. This is a carryover question from our November HOA Academy class. The question is, in a planned community, if a homeowner has an outstanding fine and violation and has already had a hearing and an appeal decision, and the home is listed for sale, can they transfer title to the new owner without paying the fines or correcting the violations? And must those fines and violations be disclosed to the buyer in the association's disclosure statement? This is a great question. So first things first, anytime there's a sale of a unit in an association where there's 50 or more lots or units, the association is contacted by the title company when there is going to be a transfer of title between one owner, seller, and a buyer and an association. And we provide what we call a disclosure statement. We have a cheat sheet on this topic if you're interested in learning more about it, called Disclosure Statements and Transfer Fees. And you can find that on our website at mulcahylawfirm.com. But really, here's the bottom line. So yes, we should be disclosing if there is a violation. Okay, so that is something that's definitely a question that is on the disclosure statement. So typically we'll say, like, let's say that they painted their house without getting approval. If it's a violation that's maybe isn't still existing, but it was a violation, that's not something you'd put out there. Like the trash cans were on the disclosure statement. You wouldn't say like the trash cans 2 weeks ago were put away. That's not something. It has to be like a current violation. Now let's go back to, you had a hearing regarding the fines that were levied. From a pure technical legal perspective, you have to have a judgment to collect those fines under Arizona law. And there's a specific statute that talks about that. That says that if we're going to fine an owner, we have to give notice and an opportunity to be heard before we levy the fine. That's what happened here, apparently. And then the fine was levied after the hearing, but you haven't had time to go get a judgment yet. So what I would recommend in this situation is I would add it to the disclosure statement. And if the owner or the owner's realtor questions it, you may have to not charge that as part of the disclosure statement and the transfer title. Or if it's a lot of money in fines, you may have to put it in an escrow and then you wait to go get a judgment against the owner and then come back and get the money out of the escrow. If the owner objects to it and, you don't want to write off those fines. But that's probably a good time to reach out to your law firm to talk about what your options are. If it's a petty amount of fines, like $250, you could add it to their account. If they question it, then you should be removing it because we don't have a judgment yet. And under Arizona law, you have to have a judgment before you can collect on those fines. Okay, next question, number 2. Is it legal to use a special assessment to increase a reserve account? It really depends on what your documents say, your CC&Rs say regarding how special assessments can be levied and used and for what purpose. So it is typically for long-term capital improvements. So it is common that it could be used to fund a reserve because you'll be spending it on capital improvements in your community, but it really is document specific for your association. Okay, question number 3. Can we use Google or some AI source to condense the massive Zoom output, like an AI transcript generated from a Zoom meeting? Really good question. We're seeing a lot more use of artificial intelligence in many different ways for associations. And this would be a good way, of course, if you want to condense it. There's a button you can click right on the Zoom and they will give you a transcript. And then you can condense that transcript by using AI. And of course, you can do that. You want to be careful, though, that the minutes of the meeting, they do need to reflect specifically what was decided at that meeting. And you just want to make sure if AI is condensing it, they may not catch everything. Sometimes it's pretty good, but you still want to have a human factor to make those minutes to make sure that it has all the important information that needs to be in the minutes for that meeting. Just kind of a crossover based on the new legislation that was passed this year and went into effect in September. If you're trying to use, AI to, instead of keeping the Zoom meeting, recording the Zoom meeting, Remember that Arizona law does require you to keep that meeting for 6 months now. So if you record a meeting, you have to actually keep an unedited version of that meeting for 6 months in case an owner wants to review it. So just remember, even though you may be summarizing it, you still have to keep that full copy of the Zoom meeting for 6 months. Okay, next question, number 3. If one of our HOA directors wants us to no longer identify who makes a motion or a second in our minutes, would doing that violate the open meeting rules? No, it would not violate the open meeting rules, but it is helpful for remembering it in the case there's litigation or something. So it's definitely not violating the open meeting rules. So to answer your question, no, it's not. But I think best practices would be to keep the names of the people who are making the motions and the seconds in the minutes. Okay, question number 5 from a board. In an Arizona HOA with a 9-member board, if 5 directors, including the president and the vice president, regularly coordinate board business and pre-decide how they will vote through phone calls and emails outside of a noticed open meeting, while excluding the other 5 directors, are these coordinated discussions and pre-meeting decisions a violation of Arizona's open meeting law? We have a 9-member board, and if 5 of them are doing that, that is a violation of the open meeting law because it's quorum. And it's the open meeting law says at any time a quorum of the board is meeting to discuss association business, you need to have it be an open board meeting. So now, if they're doing it this way, it probably would be a workaround that wouldn't violate the law. So if what they're doing is they are meeting one-on-one with each other or less than a quorum, they certainly have the right to do that under the Arizona open meeting law rules. So just keep that in mind. I don't know if they're doing it together all at once or if they're polling less than a quorum and talking about issues with less than a quorum. That would be okay under Arizona law. One thing that you might want to do, just thinking forward for your association, is it sounds like there's a high level of dysfunction in your board if this is occurring. And I really would recommend that you consider having our firm come in and do a boot camp for you and talk through the issues. We do an overview of the laws. We can bring this up when we're talking about the open meeting law and really air out the grievances so that you guys can start 2026 off on the right foot. Okay, next question, number 6. Arizona Revised Statutes 33-1818 requires a meeting for voting to retain the right to regulate public roadways. We did not have that meeting, and this question was put on our annual meeting ballot for board members. Does Arizona law differentiate between online and mail-in ballots versus a meeting? I'm kind of a little confused about this question, but okay, so let's just break it down. So apparently you're familiar with the roadways law, right? And there's very specific associations that's going to apply to. You're going to have to be an association that has your roadways that are dedicated to the public. You have to be a planned community. And you would have needed to comply with this particular law by doing a vote of the membership to retain the ability to regulate the roadways by June 30th, 2025. If that didn't occur, then you've probably lost the right to regulate your roadways. So it does say the statute required a meeting for voting to retain the right. Okay, so that was first part of your question. We did not have a meeting, but this was put on the annual meeting ballot. But then you say for board members. If it was on the annual meeting ballot, it was at a meeting. So it should have been, that would have been met the requirements of the law. So the question's kind of unclear. It's hard for me to answer it. Does Arizona law differentiate between online and mail-in ballots versus meeting? Well, what Arizona law does say is that you can attend a meeting either in person or you can return an online or an absentee ballot or mail-in ballot, and that is considered a proper vote. So you can vote at the meeting or you can return a mail-in or absentee ballot, and that is perfectly valid and legal under Arizona law. Okay, let's go to question number 7. If a board violates state laws and HOA governing bylaws, what options do homeowners have to sanction or remove board members other than through a recall or election process? Can the state, under any circumstances, bring enforcement action against a board if a state HOA law is broken? So I'm going to answer that first. So really, the state of Arizona does not get involved in any contractual disagreements between owners and an association. So we don't have an ombudsman. That is not something that the state gets involved in. The only exception to that would be like the Arizona Attorney General's office. may get involved if there's a fair housing issue between an owner and an association. But 99% of the time, no, that is not going to happen. The state does not get involved. There's no ombudsman in Arizona that is a regulatory agency. So that being said, how do you deal with a board that is violating your documents allegedly? What options do we have other than removing a board from office? First, if you're interested in finding out more about removing a board from office, you want to look at our cheat sheet on top 10 things you need to know about community association law. Number 6 on that cheat sheet talks about removal of a board from office. You can find the cheat sheets on our website at mulcahylawfirm.com. Okay, let's talk a little bit about what other options you have other than the recall. Well, you can run for the board yourself. You can outvote them at the next annual meeting. You can hire a lawyer to write a letter to the board regarding what they're doing and how illegal it is. You can go to the Arizona Department of Real Estate and file a complaint there, and you'll have an administrative law judge hear the complaint. The association will have to respond to that. There's a $500 filing fee per issue, so that's important to note. You also can file a lawsuit against the association if you're so inclined to do so. So those really are the different remedies that you have. Okay, question number 8. If a lawsuit against a community is settled, is information related to the suit still confidential, especially since the case is now part of the public record? So this question is actually from a board member. So this is dependent on what the settlement terms are, because sometimes in a settlement agreement for a lawsuit, there's a confidentiality provision and a requirement not to disclose any facts pertaining to the settlement to a third party. So if that's the case, the board may not be able to talk about it other than to say this case has been resolved and the parties are moving forward. In other times, if there's not that type of a confidentiality provision, the board can put out a brief statement with that the case is settled and maybe what the terms of the settlement were. Especially if you're like suing the developer for construction defects. A lot of owners are really worried about that. And they want to know that the association received a settlement that they're going to be able to fix the windows and the stucco and the fund the reserve, et cetera. So the short answer is yes, the lawsuit is public record. But typically the settlement is not part of the record in Superior Court or federal court if the case is in federal court. So it's going to be up to what does the settlement agreement say and what the association is suggesting to the board, what they should include in their summary, why the case settled. Okay, next question, number 9. If a condo association where the board approved a patio built out onto the common area greenbelt without removing irrigation and now impacting landscaping access, is the board allowed to approve that kind of an exclusive use common area? And if they do so for one owner, are they now required to approve similar patios for other owners who request them? This is really a great question. We see this often in townhomes and condos where an owner has a limited use area that's adjacent to their unit and they want to expand and like fence it in or something, or maybe they even want to build like an Arizona room or something in that area. The board really needs to get legal advice on whether or not that is allowable. In most cases, it's not. Especially, well, if it's a common area, it's probably definitely not allowable. If it's a limited common area, it may be able to be accomplished, but depending on what your language in your document says. And if there isn't language in your documents on this, you may need to do an amendment to allow for this. Generally speaking, it's not a good idea to do this because once one person gets it, then it turns into everybody wants it. And if it's negatively impacting your irrigation and your landscaping access to this area, it may not be something that's beneficial to the entire community. Maybe if you're going to structure this and again, get advice from your lawyer, you may need to have them put it on their own irrigation line and then they control that area and it's not part of the association anymore. There's a lot of legal considerations on that you'll want to consider. Okay, next question from a board member. In a community where the CC&Rs limit use to single-family residences and prohibit transient use or renting less than the entire lot, and the association suspects that certain owners are renting out rooms based on cars and activity, how can the association investigate or confirm room rentals without directly asking the owners? Ooh, this is a good question. Most of our clients have single-family use housing. It's defined in your CCNRs. And I mean, occasionally we'll see situations where we have multiple generations of a family living in a home. And oftentimes the board will ask, well, gosh, there seem to be so many people living in this home. Is it still single family use? The short answer would be if it's multifamily use, and you have multiple generations, that's purely consistent with the law. Now, what about the situation where we have somebody who is leasing? You think they're leasing a room, maybe, but you can't really prove it. Well, you can look on, the traditional online sources for rentals like Airbnb and VRBO and see if you can determine if the room that's listed in your association, really without better information, without actual factual information, there's really not too much you can do. Sometimes where this comes up is somebody's chatty at the pool and they say, oh, yeah, I'm just renting this room from so and so. Well, that's good enough evidence that, yes, that is, somebody's renting out a room and that may not be single family use housing. And so it's really just going to depend on what your documents say and what sort of evidence you have before you can take the next step. So, how can you investigate it? Look up online. I doubt that they have registered as a rental property, but they may have with the county or with the city that they're located in. But honestly, usually you're getting complaints and usually the neighbors are giving you evidence. Maybe they go out and talk to them, the people that are renting the room. And once you have that information, then you can move forward and send the owner a violation letter. Okay, next question, number 11. Please explain the relationship between a master HOA and its sub-associations. When there is a conflict between the master and the sub-HOA governing documents, which one prevails? Can you cite an Arizona statute on this? Well, there isn't a statute that specifically talks about the master and the sub. Typically, that's all outlined in the documents. And the master, oversees, typically is the superior overseeing association over the sub. And typically, if there's a conflict between the documents, the master association documents are going to prevail. It is document specific. And so, that's my experience. 100% of the time, that's what I've seen. There could be a situation in your association where the sub may have more powers, but I'd have to look at the documents to give you that specific information. But short answer, the master, what's the relationship? They're the superior overseeing organization. Typically, they oversee all of the common areas that are not part of the sub-association. They have a separate fee that is charged that is paid either by the sub directly or the homeowners directly to the master. They have a separate board, and they usually have veto power over things that are happening in the sub-association. Okay, question number 12. In an Arizona single-family HOA community, what flags are owners legally allowed to fly under Arizona law? Beyond the specific list of roughly 18 patriotic theme flags, and are any non-patriotic or non-election flags permitted outside of the election season? Okay, so there's a specific statute under Arizona law that talks about flags. And so I can just give you a quick 411 on that. So the Arizona state flag, the United States flag, armed services flags, first responder flags, Indian Nations flags, the Gadsden flag. I'm wondering if I'm missing anything here. Let me think. Political flags are allowed, but they can only be up consistent with the law on political signs. So can only be up a certain number of days. They have to be down a certain number of days after the election, and there's size restrictions. Also, the Betsy Ross flag is an allowable flag under the statute. So I think your question is, are there any non-patriotic or non-election flags permitted outside of the election season? I think I kind of covered most of them. Maybe my office could put that statute in there and I can revisit this question just to make sure I don't miss it. We'll add it to the end. So just the statute on flags, please, would be helpful. Okay, let's see here. We're going to go on to question number 13. We can just move that question to the end then, and I'll answer it at the end. Okay, question number 13. We had to condense this question because it was a little bit too long, but in an HOA where the board has informally allowed owners to decorate common area entrances without a written policy, what risks does this create for the association, like damage, liability, fairness, holiday selection, and how do other communities handle holiday lighting and decorating policies for both common areas and individual homes? A good question, especially because we're right here in the thick of the holidays. So, usually, in my experience, what happens is that the association decorates the common areas. The board of directors, either they hire somebody to do it, or maybe the landscaper does it, or maybe the management company hires somebody to come in and do it. Sometime, and that's fine. That's kind of the norm. Sometimes when an association isn't doing any decorating, somebody in the community volunteers, "Hey, would you mind if I decorated?" And that typically is something that prompts the board then to decorate the next year, in my experience. But so, I mean, obviously, if you're going to allow an owner to decorate the entrance of the community, it just needs to be tasteful. It shouldn't be overdone. It needs to be respectful of all religions. I mean, obviously, I wouldn't be in favor of an owner being up on like a really high ladder, putting Christmas lights on a tree, because that could be a liability for the association. So I wouldn't recommend something like that. But I mean, hanging a couple of wreaths and, putting a few green swags up, I think is not a big deal. As long as it's, like I said, it meets the requirements. It's fair, it's tasteful, respectful of all religions, etc. Usually what happens is if an owner puts something up or a group of owners does it and the rest of the community don't like it, then the next year the board is going to be handling the decorating. That's typically how I've seen it work. So most communities, like I said, handle the decorating themselves on the common areas. Now, with regard to individual homes, kind of surprisingly, we really haven't had too many questions on over-the-top holiday displays this year, but in the past, we have seen situations where we have somebody that really loves the holidays and they want people driving by their house to look at the lights. And sometimes the other neighbors really don't like that. And so we kind of have a push and a pull between the people that want to really go all out for the holidays and the people that just think it's too much. So if you're in that situation in your association, creating a holiday decorations policy is a really good idea. You can find sample ones online or you can contact our firm. We'd be happy to share one with you. The key thing is having a time period for when the decorations can go up and when they need to be taken down. And any nuisance provision should be written in there on noise and lights blinking in the middle of the night and that kind of stuff. So hopefully that's helpful for you as you navigate this in your association. Okay, question number 14 from an owner. In an HOA that is transitioning from declarant control to a homeowner board, where the declarant still has weighted voting rights and may use them to elect candidates with potential conflicts of interest, including a property manager invitee and a declarant board member's spouse, is the declarant allowed to cast these votes? Can homeowners know if those votes were used? And is there any way to challenge or limit the declarant's voting in this first homeowner election? Okay, so we have a great cheat sheet on transitioning from developer to homeowner control that I would encourage you to take a look at. I think we're sharing that with you, or you can find it on our website at mulcahylawfirm.com on our cheat sheets tab. So the question is, you haven't quite transitioned yet, and the declarant still has their weighted voting. So typically they have the weighted voting until a certain time period that's listed in your CC&Rs, and then they lose that weighted voting once they sell enough properties. And they're using them to elect candidates who they want, including declarant spouse and property managers. I mean, if they're still in control and there's no requirement for those particular people to be record owners, they can serve on the board. And so the declarant, they have the right to use their votes as they see fit. You can request a copy of the ballots if ballots were used for the annual meeting and you can see how they voted. That's one way to do it. Can you challenge their voting? I mean, if it's in the CC&Rs, that's a contract and they're allowed to do that as long as you're under homeowner control. Is there any way to limit their voting in this first homeowner election? Probably not. I mean, they have rights as homeowner too. Okay, question number 15. From a board member, is it appropriate for the board to give the HOA manager a small gift for the holidays? Is there a limit on what should be spent? That's a good question. I would say something that's nominal, like anywhere, like a gift certificate for like $100 or a gift card for $100. I think that is appropriate and a nice thing to do. Okay, question number 16. This is condensed from a board member. In an Arizona HOA, does the open meeting law require boards to only discuss issues and make decisions during the noticed monthly open board meeting? Or can boards handle some decisions between meetings and then report or ratify those actions at the next open meeting? So this question kind of raises issues of the Arizona open meeting law and what we are and are not allowed to do under the open meeting law. So really, anytime a quorum of the board is discussing association business, it needs to be done in an open meeting. And so if your board is making decisions outside of the meeting, you likely, and they're not emergencies, you likely are violating the open meeting law. Yes, of course, you can go ahead and ratify anything that you have done that way at the upcoming meeting, but at some point, somebody's going to challenge it and you're in the wrong. Because, like I said, anytime a quorum of the board is meeting to discuss association business, it needs to be done during the open board meeting. Now, some management companies and some boards think the workaround is, okay, we'll just do all this actions in between the meeting and then at the next meeting we'll ratify it. It's risky to do that because, like I said, the law says that these decisions really need to be done at the open board meeting when you have a quorum on board present. Okay, next question, number 17. We had to condense this one from a board. In a community where there is a shared main water or sewer line and the individual lines running from that main line to each unit, where does the HOA's financial responsibility end and the individual owner's responsibility begin for repair or replacement of those lines? So it really depends on what your CC&Rs say. Like, are you a planned community? Are you a condominium? The documents should say what is the area of the owner's responsibility and then what is the area of the association's responsibility. It becomes a little more tricky like in a townhome or a condo because typically they're going to only own the airspace and then inside the unit. And then if there's a water line break and it's on like a limited common element or underneath the slab or something, it becomes really kind of sticky and difficult question to answer. So it's going to be document specific. So I can't give you like a bright line rule, unfortunately. It looks like this is a condo because you use the word unit. And in that case, it probably, but I'd have to see your documents, would be anything outside of the airspace of the unit is going to be the association's. But again, I'd have to see the association's responsibility. But again, I'd have to see your documents to give you a specific answer. Okay, question 18. This is from a owner who used to be a board member. Recently, the budget for 2026 was voted down by our members. We understand that we will be working under the present 2025 budget for next year. The board wants to go ahead and increase the dues as requested in the defeated 2026 budget. The bylaws say old amount stands until such time as a new monthly assessment can be determined. The board says they are determining it. Can they do this? Okay, so this is kind of a very good question because I'm getting this question from a lot of boards right now. So this is the end of the budget season, right? Because we really should have our budget for 2026 approved before December 31st. It sounds like in your association, the board created a budget. It sounds like the owners have to approve it in your particular association. That's not for every association, but in yours, it sounds like that's the case. Was voted down by the members. And so now you're just going to be working under the 2025, just carries over into 2026, that budget. And that's proper. That's how that should be done. But the board wants to go ahead and increase the dues that they requested in the defeated 2026 budget. So despite the fact that the dues increase, that the budget was not approved by the members, the board, they have the power to increase the assessment under your documents, I'm sure. And so they just want to go ahead and do that. The bylaws say that amount stands until such time as a new monthly assessment can be determined. I'm not sure. I don't have the full section of the bylaws, so it's hard for me to comment on that. But so check out our cheat sheet on budgeting. I think that's an important thing to do. You can find that. We're sharing it with you here, or you can find it on our website at mulcahylawfirm.com. So can the board do this? Technically, I'd like to see the documents, but the board's kind of playing hardball with the community. But maybe they need to. Maybe they have expenses and they just can't meet their expenses. And it's like at a certain point, you can't go forward and pay all your bills unless you get that increase. So I totally understand this from the board's perspective, but I also see it from a homeowner's perspective where you're like, hey, we told the board we don't like this budget and we don't think that we voted it down. So go back to the drawing board with the new budget. I really think that this would be a good time for a boot camp for your association, because there obviously are some push and pull on how the board's behaving and how much money they need and what the board's homeowners' expectations are. And there's a lack of communications. I think the board should meet with an attorney and talk this through. So legally, if the documents allow the board to increase the assessment, legally they can do that. I know that the budget has to be approved, but I do think that the board would be able to go ahead and increase the assessment as long as they follow the procedures in your documents to do that. Now, it is kind of a gray area because the budget has to be approved by the members, and we're keeping with the 2025 budget. I mean, it's a gray area. It's imperfect. Let's put it like that. But I do think if the board follows the documents, they can go ahead and increase the assessment. But again, there's a lot of dysfunction here. And I think you need to talk to an attorney. You need to talk this through with an attorney. And maybe you need to have a town hall meeting with your owners to really talk through the budget and explain why we need this money and try to get more buy-in, because it sounds like the first meeting didn't go well. Okay, next question from a board. In an Arizona condominium association, what is the process and the minimum amount required to place a lien and potentially foreclose for non-payment of HOA's assessments? And what information or documents does the association need to provide its attorney to start that process? So, great question. I see that you're a client of ours, and I see that you're a condominium. And so the law is a little bit different for condominiums and planned communities right now, based upon some changes that were done in the law in the 2025 legislative session. So let's start with the condos analysis. So the minimum amount to place a lien on a property for both a condo and a planned community is 1 cent, right? If they owe money, you put a lien on the property. Obviously, we wouldn't do it for 1 cent. We usually wait until they're a couple months behind before we would put a lien on a property. Now, if we want to take the next step, which is to foreclose the lien, in a condominium, there's a benchmark, and you have to wait until the assessment is 1 year delinquent or $1,200 in assessments only. In a planned community, you have a different requirement. And the planned community requirement it was just recently changed. And basically, you have to wait either 18 months or it's up to $10,000 before you can foreclose. Now, in a planned community, it's hardly ever going to get to $10,000. You're going to have to just wait till it's 18 months. So a little bit different requirement for both the condo versus the planned community. You're a condo, so basically we can put a lien on the property once it's delinquent. We can foreclose on that once the assessment is past due for 1 year or $1,200 in assessments only. And so I would encourage you to follow up with that firm, and we can help you navigate this process as you're doing that. Okay, moving right along to the next question. Let's see. Oh, one other thing that my office is so good. They wanted me to remind you that if you are a management company or if you're a self-managed association, that you have to put in your letter before you send it to the attorney to take the next legal action. You have to put in the letter that this file is going to be turned over to a law firm for collection action before you actually send it to the attorney. Okay, next question, number 21. In an HOA where 3 of the 5 directors' terms expire before the rescheduled annual meeting and election, do those 3 directors hold over until the new election, or does the board shrink to 2 members? And can those 2 remaining directors appoint 3 new directors to fill 2-year terms without a membership vote? Okay, so this is a good question from homeowners. So you have 3 of the 5 directors' terms expired before the rescheduled annual meeting. Okay, so here's something that you should know about this. So when you have an annual meeting, if you don't have a quorum to have the annual meeting, basically what happens is those directors who are in office, they just carry forward until the new board is elected at the annual meeting. So this comes up from time to time. So let's give an example. So let's say that we were supposed to have our annual meeting in October of 2025. And unfortunately, we didn't get a quorum. And so we have 5 directors on our board. 3 of the 5 were up for election, just like your facts here. And now we're in December, and those directors are still in office because the annual meeting didn't occur. and nobody has been elected to fill their vacancy. This can even carry over for a whole year. If you try twice or something to get a quorum for an annual meeting and you don't get it, that carryover director will carry over until the next election. Now, sometimes what happens is the carryover director is like, I'm done with this. Like, I don't want to be on the board anymore. And they may resign. Then the board typically can appoint somebody to fill that position until the next annual meeting. So I think that answers your question. They do hold over until the new election. We definitely would not have the board shrink to 2 members, because the way that every set of documents is written is you are on the board until your successor is elected to fill your vacancy. Okay, next question, number 22, from an interested owner and a committee member. In a condo HOA where a 20-foot drainage easement was granted to the city back in 1980, can the association change the landscaping within that easement area without first getting approval from the city of Mesa? Well, it's a drainage easement, so that's a little different than a normal easement. So I probably would reach out to the city just to determine whether or not, I don't know what type of changes you're going to make, but if it's going to alter how the drainage is, the topography, you may very well need to get their approval. Maybe not from the person that we gave the easement to, or they gave it to us, or we gave them the easement, but it may just be through their planning department. Okay, next question, number 23. May architectural review committee actions be done solely by email if the 3-member committee all agree to approve the application and the submitting member does not ask to speak with the committee? As long as it's not a regularly scheduled committee meeting for your architectural committee, I'm fine with that. If it's going to be a controversial decision that you think another owner might object to, I would have an open meeting, because you definitely want to be hearing everybody's thoughts on whatever the change is. But most architectural committees, best practices, in my opinion, would be to actually have a meeting, but most aren't doing it. And so those are just some practice pointers for you. If you've got something that's really going to be controversial and you think it's going to be legally challenged, make it an open board meeting or make it an open committee meeting, and make sure you publicize it so that any neighbors who might be interested will be able to come and comment on it. We also have a great cheat sheet on architectural review committees that we have shared with you, or will be sharing with you. It's also on our website at mulcahylawfirm.com. Okay, next question, number 24. In an HOA where a rule says owners and their pets may only use the common area lawn immediately adjacent to their own unit, not the lawn next to their neighboring units, and requires pets to be leashed and kept off other owners' premises, is that type of limited use common area rule legally enforceable? I mean, if it's common areas, typically each owner has a right to access the common areas. I don't know if it's limited common areas. Like an example would be like, let's say you have like a fenced in area or something. Obviously, they wouldn't be able to come in the fenced in area. I think it's kind of fair game. I'm just reading between the lines here and guessing that probably what's happening is the pets are coming in and going to the bathroom adjacent to these other unit owners' homes, and they don't like it. So the question is, there's a rule that says owners may only use the common area lawn adjacent to their unit. So is that reasonable? It may not be, because if it's truly a common area and each owner owns a percentage interest in the common areas, and typically they have the right to use the common areas, that probably may not be reasonable and enforceable. Maybe the better rule is people need to pick up after their pets. I'm fine with the pets being leashed on the common areas. I think that's an important safety rule, when not allowing pets to go on other owners' premises. I guess maybe that would be their lots. That is something that I think is reasonable too. So if it's limited use common areas, I'd have to really look at what your documents say and look at how your association is structured to give you a better answer on that question. Okay, question number 25 from a board. In an HOA where the CC&Rs allow a special assessment, if it's approved by 67% of the members who cast votes at a properly called meeting, does that mean 67% of the members who actually voted the meeting, not 67% of all of our owners, which is a certain number? And can that vote be conducted electronically if notice and meeting requirements are satisfied? Okay, so you want to do a special assessment for your association, and it says you have to get 67% of the members who cast votes at a meeting. So these are tricky provisions. You definitely want to get your attorney involved to help you interpret this. But in my experience, when you have a provision like this, there's usually a high quorum requirement. So if I had to guess, I bet your documents have a quorum of 60% for this meeting. And then you need 67 of the members who actually, attend that meeting where a quorum is present. And so the language on these special assessments, increasing the regular assessments, amending the CCNRs, all of these it's very important to look at the very specific language of the provision in the CCNR. So in this case, you're right. It is 67% of the members who actually cast their vote at the meeting. But if I had to bet, you have a high quorum requirement so that you have to first meet the first benchmark is, do we have a quorum? And then if you do, then 67% of those who attend that meeting with a quorum would be able to vote. Maybe your quorum's lower, I don't know, but you need to look at that carefully. Can that meeting be conducted electronically if notice and meeting requirements are satisfied? Electronically, if you mean by Zoom, yes. And you can have members vote 3 ways, either in person at the meeting, even if it's Zoom, you can still get ballots back electronically at the meeting that way, or by absentee or mail-in ballot, and that it can all be done electronically by using emails to vote with the ballot. There's many online voting companies now that are doing that. So yes, that vote can be done. It can be a Zoom meeting and the ballots could be handed in electronically. However, we always need to allow owners the right to vote at the meeting if they want to under the law. Okay, next question, number 26 from a board. In an HOA where a committee handles CCNR enforcement and architectural review, what kinds of personal information about an individual member are allowed to be discussed in executive session under the open meeting law, like beyond health and financial information, for example? And do a member's name, unit number, or the specific nature of the violation count as personal information that can be handled in a closed session? So, great question. So anytime you're talking about enforcement, whether it's collection of assessments or a violation on the property, that can be discussed during the executive session. And you can speak freely in the executive sessions. You can see everything, the name, the address, the lot or unit number, what the violation is. And that's actually going to fall under a different category than personal information. That's going to fall under the enforcement of the documents exemption to go into the executive session. So you want to know what kinds of personal information about an owner can be discussed in executive session. Really anything. It's a private meeting with the board. Only maybe a special guest like the manager or your attorney. And if you're on the board, you are privy to confidential information pertaining to owners and violations and non-payment of dues and bankruptcies and trustee sales and domestic abuse type things that happen in a property. I mean, you do hear a lot of information when you're on the board. So there really is no limit in terms of the information that can be disclosed to the board during executive session, as long as it falls under one of the executive session topics. So the most common things that we go into executive session for are going to be violations, delinquencies, advice from your attorney. Very rarely are we just talking about something personal or financial related to an owner. Usually it's going to fall under one of those larger umbrella categories. Okay, next question, number 27. A home in our single-family Phoenix community was recently purchased as a non-primary residence and is starting 2 months of interior renovations. What due diligence should the board perform or red flags to watch for in case for the need of a proactive approach is required? The concern is that this is going to be a group home, assisted living, short-term rental, none of which are addressed in our 2002 CCNRs. Okay, well, you have a new buyer that's purchased a lot. They're doing some renovations. I'm not sure how you know it's going to be a non-primary residence. Maybe it's listed as such on the assessor's office. I think really a good thing to do would just be to reach out to the owner and send them a letter. Welcome to the community. We know that you are starting your renovations. And if you have any questions, please reach out to us. Please let us know what your intentions are for the property. Are you going to be living in the property? Are you going to be renting it? Or do you have any other plans, and see what they say? Okay, question number 28. Just doing a quick question check here. How many we have total? Looks like we have a total of 36. So we're moving right along. Question number 28. In this condo community, each owner's unit's freshwater line runs from the EPCOR meter or valve box to its individual shutoff valve. 2 leaks have occurred. One just a few feet from the meter, causing a high water bill because the water is billed to the unit once it passes the EPCOR meter. The other along roughly a 60-foot stretch that crosses the common property and areas with possible digging before reaching the unit's valve. EPCOR says anything past its meter is not its responsibility. Documents and the Condominium Act do not address who pays for repairs of these lines. Since this situation likely arises in other condominiums, what is the standard or commonly accepted legal view on who is responsible for repair costs? So it looks like in this particular condo, it's unusual, but each owner has a meter, a water meter, and usually the association pays the water, but in some cases you do take the step of having a separate meter for each owner. And it looks like there's been 2 leaks, one a few feet from the meter, causing a high water bill. I don't know who the water bill. It came to the unit once it passes the EPCOR meter, so it's going to the unit owner. The other along a roughly 60-foot stretch that crosses common property and areas with possible digging before reaching the unit's valve. EPCOR says anything past its meter is not its responsibility. Gosh, this is a hard one because it's crossing over the common areas. And if I had to guess that there's the EPCOR meter, and then I'm guessing it crosses through the common areas, and then it goes into the units based upon the valve. It's hard for me if the break is somewhere between where it goes to the owner's unit. If it's close to that, it's possible it could be the owner's responsibility, I'm guessing. But if it went to them and they didn't notice it and they didn't report it, it could be on them for not taking action in a more timely manner. This is a tough one. I'd probably have to look at your CC&Rs, look at more internally how the EPCOR meter is set up, and to give you a final answer on that. So sorry, I can't answer that, but that's a complicated one. Okay, question number 29 from a board. Our secretary is not handling minutes in a timely manner as we approve. Our secretary is not handling minutes in a timely manner. We just approved last month's meeting at this month's meeting. That's actually okay. That's how most associations run, just so you know. So I would not say that the secretary is not handling them in a timely manner, because normally you have your meeting, like let's say we have our meeting today, and then at the January meeting, we approve the December meeting minutes. That's common practice in our industry. The question is, we ask him to post both email to post both by email the homeowners on our website and on the bulletin board after our meeting. As president, I've tried to address him, but he doesn't change. Do we need to talk about this in executive session? Okay, I'm definitely seeing like a tug here between the president and the secretary. I personally don't think that the secretary getting them done by the next meeting I think that's reasonable. I think that's industry standard. If you want to have the meeting minutes sooner to be a good communicator with your owners, great. I get that. You should post them as a draft meeting minutes. And maybe, you should offer, if you want it changed, maybe you should offer, hey, can I help getting him out earlier? I'm guessing that there's going to be a little stubbornness here because it's saying that he doesn't change. I mean, I think as a board, talk about this in a non-confrontational way. At your next executive session, I think the president should just say why, you want the minutes earlier. I'm assuming it's not like a control thing. It's more like hey, we want to communicate with the owners right away about what's going on. And that's great too. And see if you guys can come up with some sort of a solution. Like maybe instead of if the secretary doesn't want to do the minutes, maybe the president writes out a quick little president's report and sends it out to the owners about what happened at the meeting. And that maybe might be a way to amicably resolve this because, like I said, the secretary behaving in this manner, that's pretty much industry standard. If you want to do it faster, it sounds like you do, then maybe you politely ask, hey, can we get this done faster? If the secretary isn't changing and doesn't want to do it, then I would just pivot and I would send out an executive summary, not the minutes, just a summary of what happened at the meeting and put it on the email and website and the bulletin board after the meeting. And that kind of is a good solution. Okay, let's look at question number 30. Can a board legally prevent homeowners from creating an independent social media platform for the community? Our HOA is 28 years old and the documents do not address this. As long as the homeowners are not making it the official page for the association. I mean, we see this with realtors too, where they create like a Facebook page or an Instagram that's a name similar to the association, but it's not the association for their business, or maybe the homeowners want to start wanting to complain about how things are going at the association. I don't think we can legally prevent them from doing this. There's free speech in our country. If they're posting stuff that's defamatory or something, that's a little different situation. We would send a letter on that. But no, I don't think legally we can prevent them from doing that. I think the bigger question here is there's unrest. Okay. And if this is happening, there's probably unrest, and you probably need to get ahead of that by having a town hall meeting and find out why homeowners are upset and why they want to start their own little satellite social media thing. Maybe it's not that. Maybe it's just that you don't have one and they want to have more communication. But still, I'd rather have the board be in charge of that than having the homeowner group being the official voice of the association. Okay, let's see. Question number 31. Can you talk about the difference between a law firm filing a corporation commission and the management company, as well as the difference between the attorney being the statutory agent and the management company? So really, it doesn't matter. You can have anyone file your annual report. You can have your management company do it. You can have your attorney do it. It's a simple form, and you pay a fee and you file the simple form every year, and it's over. There are some changes that the Corporation Commission made in the past year, so that you have to now provide some forms of ID when you are filing the annual report, which makes it a little longer to do, but it's still manageable. Same thing about the statutory agent. Really, anybody can do it. It can be your board member, it can be your management company, it can be your attorney. The one thing I'm going to say about the statutory agent, it's important because they're the person who's going to accept service if you're ever sued, a lawsuit's filed against you. And so you want that person to be a constant, and you want that person to be responsible. And we don't charge to be statutory agent for our associations that we represent. And I know that when we get served at the lawsuit, it's very urgent matter, and we need to get that to you right away because we only have 20 calendar days to respond to it. And so whoever you select to be your statutory agent, they're going to be on it. They got to be responsible. They have to have who the current contact person is for the association, and they have to have that deadline in the back of their mind and be able to protect you in the event that there's a problem, we can't reach somebody on the board, taking some sort of action to protect you so that default's not entered against you in the lawsuit. Okay, next question. Let's see. Question number 32. Can the financials just be accepted as stated by our current management company? In our prior HOA motion, motion, second and vote would occur. I don't think there is a right answer on this, frankly. I mean, as long as you're talking about them at your regular board meeting and the treasurer is giving a report or the manager is giving a report about the financials, depending on how your association does it, I think that's fine. My association, we do a motion, a second, and a vote, but I think it's not required under Arizona law. It might just be best practices so that people actually look at it and are accountable for it. Okay, question number 33. We had to condense this question. If an HOA properly blocks off newly resurfaced private roads and a delivery company moves the cones, drives on the pavement, and causes damage, does the HOA have any legal recourse against that delivery company to recover the cost of repairs? We had this happen actually at our association where I live. Yes, you do have recourse. Usually my personal experience on this is it's not that expensive to fix. The company comes back out that did it and they just put an extra coat on it and everybody moves on. So it's not super expensive, but if you're upset about it and you want them to pay for it and you can track with the camera or whatever proves that they did it, yes, definitely you can reach out to them and ask for reimbursement. It's not going to be something where they're just going to like roll over and give you money typically. It's going to take a little elbow grease, but you do have a legal right to do that. And they were in the wrong, definitely, for damaging your property. Okay, question number 34. In approving expense payments for items like repairs, landscaping, etc., via email of the board of directors, an issue that is considered outside the open meeting law. Okay, so we're going back to open meeting laws. And can we approve expense payments for repairs, landscaping via email? Best practices really would be approving expenses like this that are not emergency, do it in the open board meeting. If it's an emergency and we can't wait 48 hours to do it, then you can do it by email. Okay, question number 35. Can the board communicate regarding to waiver or reduce a fine since the board doesn't have a meeting until January 21st and the owner wants a reply ASAP? Okay, so it sounds like you've got an issue between an owner and the association and you want to resolve it in between the meeting. It sounds like there potentially could be litigation on this. It sounds like there's a fine. We regularly will be having discussions with the board. Let's see, I've got the Q&A box here. Let's see, answer. Okay, we're good. Okay, perfect. Sorry about that. Had a little internet difficulty at our building, so sorry we lost us for a minute. But we've been doing so many of these, we were able to pivot real quick. So now I'm on my phone. Okay, we only have one more question today before we go into kind of our closing remarks. But I'm going back to the flag question. And basically, I just wanted to go over which flags are allowed under Arizona law to be flown. So regardless of what your documents say, the following flags are allowed to be flown in front yard or backyard display. So we've got the American flag or an official replica of the American flag, or like the Betsy Ross flag was passed a couple of years ago that you can fly that. A flag of the Uniformed Services of the United States. It has all these flags, though, have to be flown consistent with the federal flag code. The POW flag is allowed, the Arizona State flag, the Arizona Indian Nations flag, the Gadsden flag, First Responder flag, and the Blue Star or Service flag or the Gold Star Service flag. So just getting back to the question that you had, to make sure I understand it, beyond the list of the patriotic themed flags, are there any non-patriotic flags or non-election flags permitted outside of the election season? I don't know. I think we covered all of the flags. I think that probably should answer your question right there. Don't forget the political flags. You can put those on your property or use those on your property consistent with Arizona law for political signs. So you have to take them down at a certain time and you can only put them up at a certain time. Okay, that is it for our First Fridays today. This is our last class for 2025. So I would like to wish everybody a very happy holiday. I want to remind you that all of our classes for 2026, the first half of them are now listed on our website. And we would encourage you to take a look at those and think about which ones you may want to attend. Our next First Friday is we're going to be actually talking a little bit about when the next First Friday is, because I think it falls on Friday, January 2nd. And I think we're probably going to have low participation that date. So I want to talk internally with my firm about that. I think we should probably move that to Friday, January 9th. So we're going to be posting an update for that on our website. So thank you, everybody, for a wonderful 2025 and for caring about your associations, attending our classes, giving us great questions, which help others learn too. And we look forward to seeing you again in 2026. So Merry Christmas, Happy Holidays, and have a great, wonderful holiday season with your families. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.